So as our next group of panelists comes up, I'd like to introduce a colleague of mine who, when we were putting this panel together, she really seemed like the perfect person to be able to lead this conversation. Sarah Gustinek, she is Associate Vice President and Chief of Staff to Dr. Bashir, who you all met this morning. She, in this strategic role, partners with leadership to shape policy, guide collaborations, and ensure that all of our initiatives align with the university's mission and policies. She has extensive experience in higher education administration and legal compliance. And of course, she's situated in the health sciences with us. So she has a ton of insight, making her the perfect voice to lead this conversation, situated at the crossroads of health and law. We also have Caleb Mammon, who is an attorney with Neighborhood Legal Services in Western New York. He focuses on advancing justice and access to care through medical legal partnerships, and he provides legal advocacy and support for vulnerable populations, addressing the social and legal barriers that often impact health and well-being. Through his efforts and the agency, they work at the intersection of law and medicine, supporting individuals to receive not only medical treatment, but also legal protections and resources essential to long-term stability and wellness. Kevin Quinn, I haven't seen Kevin. Kevin, are you, there you are. Okay, come on down, please. Kevin is the managing attorney at the Center for Elder Law and Justice in Buffalo. He plays a key role in leading the organization, and in this capacity, he oversees legal services and advocacy efforts designed to protect and empower older adults and vulnerable populations here in our community. He has extensive experience in elder law and deep understanding of the legal and social challenges facing aging communities. And then lastly, I want to thank David Augustinek for joining us today. David is an accomplished real estate sales professional with extensive experience here in Western New York. He's been a licensed real estate salesperson since 2015, and he currently works with Hunt Real Estate. And I could list all of the awards that he's received since being in that field, but they're too long and countless, so I will skip that. David, I invited to join this panel because I think that navigating real estate transitions is a critical element for so many of us. Many of us have experienced it, myself included. He has recently and successfully helped a number of family members navigate this complex process, giving him firsthand experiences on the challenges that families face. And I can actually say that he is highly knowledgeable, but beyond reproach ethically, making him a trusted source for families navigating these difficult situations. So thank you, Sarah, for leading, and thank you to our panelists for joining.
Thank you, Jill. And hello, everyone. This is going to be, I think, a really informative session and something that, as an attorney and as the wife of a real estate agent, that I'm personally interested as well. So I'm going to get started, and then we'll open up to questions after the panelists answer their questions. So the first question is for Caleb. When families are faced with a parent who suddenly loses capacity, what are the first legal steps you advise them to take?
Yeah. Do I need a mic?
Yeah, let's hit the mic.
All right.
No.
Can everyone hear me?
Yep.
Okay, great. I'm going to answer this question by posing a different idea. So I think ultimately the best time to address the loss of capacity is far before the sudden loss of capacity. And I would say not being afraid to have those conversations with your loved one is super important. It's never easy to talk about potential loss of capacity or chronic health issues, right? And what that might mean for their lives. However, if you're faced with, a sudden loss of capacity, I would say, there's this concept in the law of least restrictive means, right, for help. And there's a lot you can do in the form of supported decision-making with a loved one, short of seeking guardianship, which may be necessary, but may not be.
Great. This is for Kevin. Medicaid eligibility is confusing, as we all know. What are the most common mistakes that families make when applying for long-term care coverage?
So yes, it is very confusing.
Mhm.
And, um, I think you'll hear a lot of buzzwords throughout, our responses, but one of the things I'm sure most folks have heard is the 5-year look back period, right? And so, we have folks who are trying to plan and are trying to protect assets, and we have an individual who maybe wants to put their home in their children's names and keep a life estate for themselves. That's great planning. However, if down the line, if you have to apply for Medicaid, um, DSS is going to take a look 5 years back in your history and see all the financial transactions you've made, any real property transactions you've made. And if you haven't been justly compensated for the transfers you've made, it's likely that you're going to have a sanction period where Medicaid is not going to cover a stay in a skilled nursing facility, for example. So as Caleb mentioned, really, it's never too early to start planning for these things because, the clock starts rolling. And, the same goes with transferring finances. If you're giving money to someone, are they going to pay you back? Is that documented? Really, the best advice I can give is imagine having to explain your financial life for 5 years to an organization. And can you do that? Can you provide proof that, yes, I gave money to my son, but it was returned? You really have to be able to protect yourself. We're talking a lot about caring for parents, caring for children, but you have to protect yourself as well. You have to be your own best advocate. So having a paper trail of everything is really the best way you could prevent a lot of headaches in the future.
Great, thank you. The next question is for David. How do the needs and priorities of older home sellers or buyers differ from those of your younger clients?
The majority of the older clients, they're looking for family for less maintenance on the home. Oftentimes want removal and long that they do not want to take more to smaller. Just
Great.
let me elaborate on.
My next question is for Caleb. How do you approach cases where siblings disagree on whether guardianship is necessary or who should serve as the guardian?
Yeah, so this is one of the toughest things about caregiving, I think, is when family disagrees on the approach. I'll kind of build on something I mentioned last time, which is, conversations far ahead of time can help to head this off, right? So if there are documents in place like a healthcare proxy, which delegates healthcare decision-making authority to an agent, or a power of attorney, or both ideally, that may delegate the ability to make financial and legal decisions to an agent, these things control, right? And so despite any disagreement, the individual who needs the caregiving has already spoken, has said, I want so-and-so, be it a child or a spouse or whoever, to help me with healthcare decisions. I want so-and-so to help me with financial and legal stuff. This is the best way to head this off. If it hasn't been headed off and there are sibling disagreements on approaches, for me, it always comes down to the desires of the individual who is needing the caretaking. So that conflict, if it lands on them, is going to be really harmful, right? So this individual is already perhaps ill, they are already aging, they're already needing help and losing some autonomy. And that's a really painful situation to be in. It's really difficult. And I would say those siblings, it falls on them to seek some kind of mediation or conflict resolution regarding their conflict in approach. Because if it lands on the parent, it's going to be a really painful situation, right? And the key to a lot of these issues is trust. Conflict erodes trust. And one other thing I would say, I know I mentioned supported decision-making. New York State has a structure for supported decision-making with respect to individuals with intellectual and developmental disabilities in the mental hygiene law that can, and I believe should be applied to individuals who need care who don't have intellectual and developmental disabilities, who are aging, who have other difficulties. And supported decision-making is essentially sitting down in an agreed upon context and saying, what do you need help with? Is it paying the bills? Is it medication management? Is it making appointments? What is it? And who among us, siblings, spouses, friends, who can help you accomplish those things, right? And coming up with an agreement of sorts that says, we are going to help you do X, Y, and Z, but you are still going to retain autonomy, right? Because I'm a firm believer, and that's one of the most painful things about needing caregiving is the loss of autonomy.
Great, thank you. My next question is for Kevin. How do you advise families who are trying to balance savings for their children's futures while also preparing for an elderly patient's care needs?
Very difficult. I think this is often easier said than done because there's so many what ifs in life, right? But I think we have to look and kind of forecast what we're going to see for our children and what we're going to see for our parents. What do we believe might be more imminent that we need to focus on, and what expenses may be more long-term, right? So child's heading to college next year, that's, something you wanted to have been prepared for. Nursing care for mom or dad might be a bit down the line. Again, we'll never know for sure, but trying to forecast where you're going to need support is very helpful. Having a plan and having discussions with your loved ones is very helpful. Having others involved to the extent that they're on board and saying, using a lot of the resources that are available. So is there a 529 started for child's education? Is there a trust that's available to maybe protect some of mom's assets? Trying to forecast those things, again, as difficult as it may be, is really necessary to try to manage both generations and support both of them.
Great. And as a follow-up, and you kind of touched on this earlier, what role does estate planning play as part of these sort of navigating this, older generation's needs and your children's needs?
Estate planning is a crucial piece to managing. Having a will helps to ensure that a property is going to stay within your family for the next generation, so that other generations can benefit to us at the Center for Elder Law and Justice and said, well, my property's in foreclosure and my mom and dad owned it. My mom and dad passed. I've been living here my entire life. What do I do? They really don't have the legal standing to fight a foreclosure action because they don't own it. They're not even named as an executor in a will where they have that legal authority to step in and try to fight a foreclosure action. So having a strong estate plan where you can name someone to jump in as an executor and manage property, or maybe it's a power of attorney where you're giving someone the authority to manage real estate. It puts you in a position as a caregiver to actually have the legal authority to step in when you otherwise might not have been.
Thank you. The next question is for David, and he and I actually moved both our parents long time home. How do you help clients manage that transition?
Often they are very unfamiliar with the process because maybe they've lived there 30 years. My parents, 44. They had no idea where to start. So basically helping them out step by step is a huge help. Setting them up with the first person then maybe putting them in contact with junk removal, things like that down the line, things they're going to need. You just be a point of contact for them. And to be honest, those clients usually take a lot more of my time. I touch base with them on a daily basis, or as where maybe a young home buyer, they'll kind of let things go. They have a lot more questions. Plus, you know, this is the last time they're doing this, most likely, right? So they want everything done correctly, and they're going to rely on me to set them up with a closing attorney they probably don't have, because they haven't done it in 25, 30 years. Or, for example, like contractors, if they need some work done, they may be unfamiliar with that. So things like that, just help them out as much as I possibly can. More of a expediter of the deal, helping them out as therapist half the time.
Absolutely, thank you. My next question is for Caleb. How does guardianship intersect with financial exploitation concerns among older adults?
Yeah, this is a really poignant question. I'm certain that CELJ sees this as well. We, Center for Elder Law and Justice, sorry, acronyms. I'm sure that CELJ sees this as well. You know, folks coming in and saying, you know, I think my child might be taking money from me, or, you know, something like that, right? And I would say, we'll take a step back and just talk about guardianship, right? The court process is adversarial, meaning that you're putting a decision before a judge and someone's going to win and someone's going to lose. Adversarial situations erode trust, and the erosion of trust increases family conflict, and it exacerbates things that may already have been there. So just as a backdrop, I'm not saying guardianship is never appropriate, but just as a backdrop, right? If people have been to court to seek guardianship, that's already there. And that's almost impossible to avoid. And I do see situations where people come to me and say, I think someone's taking money from me. I think someone sold my house out from under me, my car out from under me, you know, something like that. And it goes to the point of guardianship is a last ditch solution, right? Guardianship, in my view, should never be the first stop when caretaking, because guardianship really reduces someone's autonomy, takes away their decision making. Guardianship in some ways is very similar to child custody, right? A child has no, I shouldn't say no, a child has very diminished legal responsibility and ability to make decisions for themselves, right? Which sort of increases as they get older. But imagine being under guardianship and you've had this autonomy and now you don't have it, right? And so it does open up situations where financial exploitation can happen. And fortunately, a guardianship can be removed, but I will say that's a very difficult process. Very difficult, right? Because imagine the person under guardianship has already been determined to have diminished capacity, right? And so as a witness in the attempt to remove a guardianship case, right? Imagine how credible their word is going to be, right? And so it does become very difficult, and it's very sad. It opens people up to a lot of exploitation. And again, many people who seek guardianship over parents or others who need care do a great job, right? Many do a great job. Some do not, and some have malintent. You know, that's a situation that is frankly quite hard to sort of deal with on some levels, right? Because you have given your decision-making authority to somebody. And again, I'll make a plug for some of that prior planning that we've all talked about, right? Which is healthcare proxy, power of attorney, will. These things, if they're made when someone does have capacity, can head off, you know, not all, but a lot of the issues that come up with guardianship and the conflict that may come up.
As a follow-up, do you see guardianship reform actually changing how families will navigate these issues in New York specifically?
I hope so. There has been increased push for various alternatives to guardianship, The recognition being that, guardianship, again, is a very strong legal remedy. It's, like I said, it should be, I believe, a last resort, right? And one example would be, again, this supported decision-making, right? Which in its current form, in the statute applies to folks with IDDs, intellectual and developmental disabilities. But I will say, just because this statute covers those individuals does not mean that supported decision-making can't be used as a model for everyone who needs caregiving, right? Because really it's based in a dialogue. What do you believe you need assistance with? What can we help with? How can we support you? And what decisions can you maintain the authority to make? What can you do, right? Guardianship is all about what someone cannot do, largely. Supported decision-making is about what can you do and also what you might not be able to do, right? It's much easier for someone who needs caretaking to participate in that discussion and to feel like, and the reality is, they are involved in the discussion, right? And they should be, right? And my hope is that as time goes on, the legal structure might change. Also, that there might be more resources for supported decision-making, because often it does require a facilitation. It's hard for families to sit down amongst themselves and do this, right? People need some guidance, some facilitation. I would want some facilitation in my life if I were going through this process with somebody I was caring for. And yeah, I think my hope is that even solutions that we haven't even thought of yet to guardianship, alternatives to guardianship, will be embraced going forward. I truly believe that, most caregiving, caretaking, care partner situations can be resolved short of guardianship.
Great, thank you. The next question is for Kevin, and we touched on this a bit earlier, but I think, from a broad perspective, in your experience, what strategies work best to help families avoid financial burnout while meeting caregiving obligations at both ends of the spectrum?
So I think that it does tie back to the previous question in, if you have others who can help support, having a team makes it much more easy than having to go on your own. And I know that's not the case for everyone, but if you're able to kind of split duties to make it more manageable for yourself, and a lot of adults are working and trying to care for parents and children at the same time. And so having a support group is, if possible, is key. We talked about powers of attorney a bit. A power of attorney document allows you to appoint up to 2 people to act at once. It could be more. And also 2 or more people to serve as successors. So if you're not, if you're named power of attorney for a parent and you have to go out of town, you have life obligations, another person can step in and fill your shoes. So, a power of attorney doesn't automatically always have to fall on one person. Sometimes that's just the way the situation is. But it's also important to remember that what we always tell our clients when we're working on a power of attorney, by signing this, you're not saying, I can't manage my finances anymore. This is done while you have capacity, you have the decision-making ability, and you're still able to exercise that. You're naming someone who could step in the event that you can't. If I name my wife as a power of attorney and I go out of town, she can manage my things for me, or vice versa. But I'm not losing any of my authority by appointing someone else. But if you have more people, if you're able to appoint more trusted individuals, that makes it easier on each of them, so the entire burden doesn't fall directly on them.
I think that clarification is really important, because I think people hear power of attorney and they automatically think I'm handing over rights right now. And the reality is, as you mentioned, the timing is critical, and helping your clients understand that this is a prerequisite step that's necessary, and it's important to do it while you are deemed capable. I think that's a really, really good distinction.
In my experience, that has made very difficult conversations go a lot better because, you know, people tend to think when they come in to sit down with an attorney and sign a form saying son or daughter is now my power of attorney, that they can't do anything. And that's not the case. And sometimes hearing that helps them to realize, you know, that this is good for me and I still have some independence as well.
Thank you. My next question is for David. Are you seeing more demand locally for age-friendly housing, smaller homes, or multi-generational living options?
Yes, definitely. The most competitive type of home would be a ranch. So it's much harder to get a ranch. Everyone might like a ranch, but the older people who are moving from their colonial, who are avoiding steps, they need it. So now you're competing with people who just want it, and then you're the people who need it. And it's a supply and demand. Colonial homes are a lot easier to find now. It's still competitive, all depends on location, things like that. There's a lot of factors, but the single floor living plan is definitely increased, and certainly anything that has a first floor bathroom or first floor bedroom with bedrooms maybe on the second floor as well, those are really popular too, because people who have been in a colonial, they don't maybe want the ranch, but they need the bathroom and the bedroom on the first floor. They do not need steps anymore. It's becoming dangerous for them to take them.
And as a follow-up, how has the Buffalo housing market evolved for older homeowners, especially with, as you mentioned, rising property values and limited inventory in those types of homes?
Well, the ranches, yeah, like I said, they're selling for more money. I am seeing a lot of the new builds now are incorporating a patio home style home, or just putting that first floor bedroom in to make sure that there's a first floor bed and a first floor bath. That way you're opening up to more buyers anyway. To me, it's a logical thing to do. If I were building homes, I would do the same thing.
And we noticed too, as we were shopping for our parents, that, you know, and that it was more competitive, most
Much, yeah.
definitely. And you're also dealing with, you know, a certain client challenge.
A lot of these new patio home communities they're putting in have very small lots. They have an HOA that's cheap, maybe not offering, say, a pool or tennis courts, but taking care of the lawn and snow, because that's something people don't want to deal with. The smaller lot, the better. But then people are also, they don't love having their neighbors on top of them, so it gets tricky. But they're certain about the builders seem to be trying.
Certainly. My next question is for Caleb. What can caregivers do now to make sure their parents' wishes are respected without, as you mentioned, the court involvement later, which is, as you indicated, really not desirable because it's an adversarial process?
Yeah, so much. From a non-legal perspective, and I know from my own experiences, losing my mother, seeing my parents lose their parents, right? You know, and caregive for them as well, right? That, you know, some empathy and some thought about how we formulate those conversations is super important, right? And I think you know, using the car as an example that was used in the last panel, right? Maybe not leading with, you shouldn't drive anymore. And saying, how are you feeling about driving these days, right? Opening it up like that, you're going to get to the same place, probably, right? But, you know, having that sort of empathetic and careful conversation, that is super important. You're not going to know what this individual, your individual needs until you know, medication in a pill holder that was all mixed up. That's an objective thing you can see, right? But most things are not taking place in that context. They're far more subjective. They're about confidence, autonomy, ability to do things, someone's self-conception, right? And having that conversation, right? From a legal perspective, right, then you get into what can you execute or what can you do to make sure these are in place? And we've mentioned a lot of those things, right? Healthcare proxies allow someone to step in and make healthcare decisions for you if you're not able to express what you want, right? And that can be accompanied by a living will, which can add some more detail as to care that you want, care that you don't want. Things as simple as, there's I think it's called a burial agent form that the Department of Health has, which allows you to delegate the handling of your remains to another individual, right? It's a slightly morbid thing to talk about during life, right? I talk about it with clients, and in the end, I think it gives most people a great deal of satisfaction to know, okay, I have put it on paper. They know what I want. No one has to discuss it, fight over it, not understand what I want because I've said what I want, right? That can be super important. And the power of attorney, again, can be super important. A will, super important, so that folks know where their property is going to go, that it's going to go where they want it to go. They have trusted executors who can handle the management of their property upon their death and take care of that process, right? It's the unknown that terrifies people, right? And now we're treading into psychological territory, and I'm ill qualified for that, but
I'm sure we have a psychiatrist in the room somewhere. Anyone? I'm going to open up a question to all of the panels. If you could give one piece of advice every sandwich generation caregiver should follow right now, what would it be?
Talk to Kevin.
So I would say, and we mentioned this a few times, it's never too early to start planning. And also, I mentioned this before, but you have to be an advocate for yourself too, and you have to protect yourself. And I know that's easier said than done when you're caring for multiple generations at once. But we see this quite frequently at our office where an individual is coming to us and mom or dad had to go into a nursing home and they were told they should sign an admissions agreement. And now maybe there's a bill because there's a period of non-coverage from Medicaid or for whatever reason. And now they're being pursued for the bill, right? Because maybe they have more assets that a nursing home might be able to recover. You really have to protect yourself. And you can do that while still making sure mom or dad or son or daughter's best interests are at heart. But you have to watch what you sign, and to the extent you can, you have to use time, and time is on your side. It's okay to say, I'm going to have to take a look at this and end the meeting and come back to you. During COVID, I know there were a lot of stories of folks who had to sign admissions agreements in vestibules of nursing homes because they couldn't come in. And I had a client tell me he once held an admissions agreement against the wall and wrote his name because that's what needed to be done for mom to be admitted. But to the extent you can, you have to use time to your advantage and seek help if you can. Ask someone to review this. What am I opening myself up to, if anything? But taking time and taking a step back and thinking how certain decisions can implicate yourself as well is really crucial.
David?
The very first thing I would tell somebody is to talk to a person like Kevin. They need an attorney. They need to get the living trust. You need to do these things while the cognitive awareness level is still there. It can decline quickly. If anyone's ever experienced dementia or Alzheimer's, it could be quick, and that can get really ugly, and nobody wants to deal with that. Sarah and I are personally dealing with that right now. So,
And even physical decline. I mean, Dave's parents are cognitively fine, but we've had 2 or 3 injuries that are unexpected in the last year or two that made moving physically very difficult, and we weren't expecting that. So I think having those preparations, even when you're having an unexpected injury, it can complicate a move. It can complicate any of these other issues as well. I want to have time for for our audience and Zoom audience to ask questions as well, because I think that this is a topic of interest. So there may be some questions in the room or question otherwise. So we'll open it up, and I'll happy to bring the microphone around.
I got it.
Oh, thanks, Jill.
Um, so recently, within the last month, we sold our house and bought our house. My mother moved in with us, and it was because I don't know. There's just something in my gut that's telling me that my mom needs just to be a little closer to us. So, Dave, when I was looking for an in-law suite in this area, either they were above a garage, in a basement without windows. They all involved stairs in some way. So we ended up having to compromise on a house that had a master suite downstairs so my husband and I could, because I don't want stairs anymore. I mean, I hurt my knee a couple months ago and it's like, I had to sleep on the couch for a couple days. Like, so I don't know, what can you speak of in this area as far as real estate for like, again, an in-law. So my mom is basically living in the office on the first floor because she does snowbird. And I think that's a lot of things. And that's one of the reasons why we brought her into our house, because she was spending all this money on rent for 5 months a year that she didn't live here. So from a real estate market, but also from a trust standpoint, I will say having a trust was super easy to navigate the real estate transaction because she was able to use the money from the trust to help support that transaction. So I just wanted to mention that to the panelists to see if there's anything you can add to our situation of, trying to have a multi-generational home around here.
The type of home you're looking for is difficult to find. And once you find it, my advice is to just jump on it and bid as high as you possibly can. Big picture, at the end of the day, you're not going to care about maybe $10,000 extra if it makes you happy and fits your needs. But I actually, 2 years ago, had a radiologist come in from Las Vegas to your trust point. Now he's worried about malpractice. So he's had to protect his wife and daughter and himself, he has had his home there in a trust for a while. So that 5-year look back is very important. My client was ahead of that. Super easy transactions when you have the trust set up as well. Everything's in the trust. It just transfers the money right over. It makes everything a lot easier. I definitely advise that. I believe there's, is it a living? I can't remember the name of it. There's another way to do it. I think it's called a life estate deed. Does that sound right? Which is a little cheaper, I believe, but the interest gradually decreases. Kevin, can you explain a life estate deed thing?
So a life estate is a form of property transfer where you have the grantor granting a property to the grantees, but the grantor is retaining a life estate, meaning they have the legal right to reside there for the rest of their lives. Upon their passing, the life estate is extinguished and the remaindermen, the grantees, have full ownership of the property. During the individual's lifetime that they have the life estate, they're responsible for taxes, upkeep, all those things, just as a regular property owner would. So that can be I guess, an alternate route to go. That is a transfer. So when we talk about look back, that technically is a transfer. Even though you're retaining the ability to live there, you're not exactly retaining ownership because ownership's now going to someone else.
Having bar exam anxiety from the grantee. Yeah. Other questions from the audience or on Zoom? We have one right about that, Jill.
I stand to lose the house. You said not to sign anything. I haven't signed anything yet.
So you're asking about your home in the event your husband's in nursing care. Well, there are certain circumstances where if you're worrying about Medicaid or Medicaid lien on a property, there's certain instances where your home can be protected. So I'm sorry, I can't give you a clear answer. There's a lot that depends on that. But in not every circumstance is Medicaid placing a lien on someone's home because they're owed money. Depending on how the property's titled or depending on who's residing in the property, there can be ways around that.
So I think the answer is it's really important to seek legal guidance as soon as these issues arise. So if there are things you can do preemptively, you can do them now. And if not, you can at least go into the situation with eyes wide open.
You. Can you tell us what avenues are available to people who don't have the socioeconomic means to enlist your services?
I think we have Caleb and Kevin who are from Neighborhood Legal Services and Center for Elder Law and Justice. So I think that you guys can speak to what's available.
Yeah, so with Neighborhood Legal Services, I direct the Medical Legal Partnership, and we have partnerships with 4 health systems in Buffalo, Evergreen, Catholic Health, Roswell, and the Veterans Administration. And so we get direct referrals from care coordinators, social workers, doctors, nurses at those facilities. And those patients come to us, and we can address the social determinants of their health by trying to address the legal issues that they're encountering. We do serve only low-income clients. Our income thresholds are a tad higher if someone is a patient at one of our medical partners. But, you know, the federal poverty line is artificially low. And, you know, I don't know what Saljay's eligibility is. I'll let Kevin speak to that. But yeah, we serve only low-income clients. And so someone can contact Neighborhood Legal Services directly as well, and do an intake. We do housing, estate planning, family law, disability cases, almost any civil legal issue that we're sort of allowed to do, given our funding strings, we do in the Medical Legal Partnership.
And our organization, the Center for Elder Law and Justice, example, our eviction defense, Neighborhood Legal Services, and Saljay, we take turns in court representing thousands of tenants every year. Our office, we do have this similar, financial guidelines that you have to meet certain income criteria in order for us to be able to assist. We do offer estate planning, but I say that because we really offer small estate planning. If it's a home and, maybe some modest, accounts, we can help advise and try to protect those. We do our best not to try to step on the toes of the private bar, because if we were taking large estates, they would have the private bar knocking down our door and asking us why we're doing that. And the funding that we have is meant to help folks of lower incomes and help them plan for the future. So there are
So I've heard from most of you, and your position is one of advocacy for planning. What's preventing more consumers from getting ahead of the chaos and the crisis of putting all the legal docs in place only after an event happens? So what's the impediment to planning? Why isn't society getting ahead of that curve?
From what I've seen, it's that the people who need the assistance don't want it, and they're in the mindset, oh, I've got this, I can do this. But with a 5-year look back, you have to do it at the right time, and they're not in the mindset to do it then. They think they're good and everything's good until there's an injury, and then they realize, oh, they have before it's too late, because it could just get a lot uglier.
And I think too, it might be helpful for, as us in the sandwich generation, to do it along with perhaps our parents, because we should be doing it too. And perhaps doing it, everyone doing it together. can sort of, preface it as a normal process that everyone should be doing as part of life planning. And so I think that's important too. And I also think, again, we're under stress, we're under stress from our jobs, we're under stress from the world, we're under stress from our kids. And so, everything gets put on the back burner until it can't be anymore. And that's just the nature of life. So I think sometimes, making it sort of a family event or a family process can sort of destigmatize it, and it also can help you walk your parents through it, so they don't see it as overwhelming. But I'll let it speak.
I had another fragment of an answer too. So, and with my clients and probably Saljay's as well, right? They are already traumatized by what they're going through in life, despite dealing with medical vulnerability and caretaking, right? So I have clients who are struggling to keep their SNAP benefits. I have clients who are struggling through 3 years long disability claims that have been dragging on and don't make their rent, right? And so those are things that keep my clients from seeking out this planning, because they are triaging, how to get food on the table and keep a roof over their head and pay for the heat. And that's not everybody, but it's a significant portion of folks who I see for sure.
Sarah, we have another question here.
First of all, thank you all so much for being here and sharing some of this information. It's setting off all the to-do list that I thought we had things pretty well under control, but there's probably some gaps and things. In terms of all of the, power of attorney, executor of the will, my husband and I are most likely going to end up being the default children for some of these, especially with siblings who are out of state. As much as we are keeping lines of communication about everything open with those siblings and families out of state, what are some ways to navigate those legal appointments when you need to sign things? I mean, I know we're getting so much better with a lot of stuff in this age of technology, but what do you recommend for those appointments or for things that need to be signed for those siblings to also take on some of the power of attorney, for example?
So I think, something that, we pride ourselves in our organization, and I know Neighborhood Legal Services as well, is we work with a lot of clients who are homebound, and we don't want having to come downtown prevent you from getting these essential documents in place. And I can't speak for every attorney, obviously, but the extent possible, we try to meet with people and make it as easy as possible to get things done. We go to nursing homes, we go to hospitals, the medical legal partnerships, obviously. Attorneys are seeing folks in hospitals. But for those individuals who are out of state, when we consult with a client and the client's considering who they want to appoint as their agent and a power of attorney, they may say, well, I have a son who lives here locally and I have a daughter who lives across the country. Well, the first thing is you want to appoint someone who you trust and who you're confident is going to be able to carry out your wishes financially during your lifetime. But, if you have the option and really both you're comfortable with serving, obviously the local one's going to be better. The local one can go to your local bank for you. And I know, there's online banking and everything. A lot of the clients that we serve aren't utilizing online banking. So they need someone to go to a teller in person. You could, what we would suggest in those cases, well, maybe the out-of-state person becomes an alternate agent, or maybe they're also a primary agent, but you can allow your agents to act separately. They don't have to be together every time they're serving as agent on your behalf. So, trying to structure it in ways where maybe both are listed, but both aren't always required can be helpful when you have those, out-of-state agents.
I have a follow-up question in a similar vein. What if you have a sibling that you want excluded from the process and parents are in agreement? And my dad, one of his best friends is his attorney who's older than him, and he said we're all fine, but trust but verify. How can I be sure that my sibling doesn't have any voice in any of the medical issues or the decisions about how to care for them?
I would say this goes to one thing I was going to piggyback off the last question, which is like if you want an out-of-state sibling in the loop, I often talk with folks too about you can let people know what you're doing as power of attorney, right? Hey, I'm transferring this money. I pay this bill. I did this thing. Now, the flip side of that, if you don't want someone involved, I think, for me, it comes down to the client sitting in front of me. And for me, that's the principal, the person making the healthcare proxy, the person making the power of attorney. So if they want someone excluded, their wish is my command, right? But I would say there is always some tact involved. And I do not only the legal aspect is something that we advise on, but the social and interpersonal aspect, right? Again, I believe the basis of these types of family dynamics is trust. And as an attorney, I have an obligation not to contribute to eroding trust in someone's family, right? To the extent possible. And so I would say, I would think about the reasons why they want this person excluded. And often it's that they don't trust them to carry out their wishes, to be available, to act in their interest, right? And that's a really good reason to not have someone as your healthcare agent or your power of attorney agent, right? If I can't trust somebody to do what I would do, I don't want them doing that. And I think what I tell folks is you can still exclude somebody without excluding them, right? They may not be in the legal documents, but you can keep them updated. You can let them know what's going on. In fact, you probably should, right? In some cases, people have shut family members out completely for good reason, and that's fine too if that's their choice. But typically, updating and letting folks know what's going on is a good thing, even if they're not the legal agent.
Thank you.
Great.
This touches on, a lot of what everyone has said already. But, you talked a lot about trust. You mentioned it several times. You mentioned supportive decision-making, facilitation, et cetera. So what happens when, some people have already asked this question, when the family is actively in discord, all on different pages, and you're trying to get care for your loved one, you're trying to coordinate that, you're trying to pull that together. And, you have multi-generational families living together, each on a different page. You didn't use the word mediation at any point. Is that within your umbrella of services to be able to, or is that somewhere else altogether, like counseling or mental health or,
Well, I mean, as attorneys, and we like to have conversations, and we do our best to, and obviously at our client's direction. But if the goal is to get everyone on board or to at least make sure everyone's aware of a plan, then we try to do that. If there's disagreements, ultimately our client is our client, and like Caleb said, we're going to do what our client asks us. But I know that doesn't necessarily make relationships between family members much easier. There are, if needed, there are mediation services that can step in. That's not something that, at least within our office, we directly provide. We do try to counsel as best we can, but sometimes it needs an extra step. And there are agencies, nonprofit agencies, in fact, that can provide mediation services for situations like that.
I believe Supported Decision-Making of New York has a facilitation service that they will sit down and have conversations with families and try to create plans that will work for folks.
I think having that neutral third party in those circumstances is critical. So if you can find an agency that can work with you within your budget, that's great. If not, even perhaps a family friend who is in this realm. Or I think having sort of that neutral party in those circumstances can be critical. And doesn't have any vested interest as well.
So I'd like to thank Sarah for moderating and contributing her expertise. Thank you to each of you. I think we all learned that there are so many things that we don't know, and the complexity of the space that you're in is something that is critical to moving our families forward, especially in this space. So thank you for taking the time today and joining us, truly.